And I'm Miriam Ellman. Many of you know me. I'm an associate professor here at Maxwell in the political science department, and I'm a faculty affiliate of INSCIT. INSCIT, as you know, is the Institute for National Security and Counterterrorism. And this talk today is part of a lecture series that is generously funded by the Carol Becker family, who is with us today. So thank you very much for your support for our institution and our programming. So this is the Middle East Security Speaker Series, and it's a great pleasure to have Professor Eugene Kontorovich with us today. He's a professor of law at Northwestern University. He has a BA and a JD from the University of Chicago. His research is very cross-disciplinary, actually. It spans many fields in the law and also in economics, constitutional law, international law. He has a CV that's way too many pages for me to describe all the different articles and papers, but he has expertise in transaction cost analysis, private law to constitutional law. He's a leading expert on maritime policy, although he won't talk about that today, but if you're interested, he has a lot of work. He's writing a book with Harvard, under contract with Harvard University Press, called Justice at Sea. He has been relied on in many foreign relations cases. He's testified at federal court, and I think in Congress he testified as well. And he has spoken everywhere in the U.S. and abroad. Now, that's his day job, okay? But in his spare time, you may know that Professor Kontorovich is also a contributor to the Washington Post, where he writes regularly a column, and his op-eds and his blogs are shared widely in the U.S. and internationally. And at Washington Post, Professor Kontorovich has written extensively on the legality of Israel's settlements and on the anti-Israel boycott provisions of various laws and measures. And if you haven't read them yet, he has two terrific blog posts that were just published last week that look at the Obama administration versus Congress's position on opposing boycotts and economic warfare against Israel. You don't have to have a law degree to understand what Eugene writes. He writes clearly, he writes very, very well, and he does such a good job at elucidating the legal issues. He's done a tremendous service, I think, for the discourse and for the debate, both in the academy and for policymakers. And today he'll speak on contemporary law issues in Israel and Palestine, Israel's borders and settlements in international law. So we'll go for about 40 minutes, and there'll be time for Q&A. Thank you so much. Thank you for coming and joining us.
Thank you so much for having me. Thank you very much to the Beckers for sponsoring this. Perhaps few geopolitical contexts are so suffused in the public discussion of them with international legal terms and discussions as the Israeli-Arab, Israeli-Palestinian conflict. Public discussion of Israel's presence in the West Bank, in the Golan Heights, is almost always paired with a legal characterization. Israel's occupation, which is illegal. Israeli settlements in the West Bank, which are illegal. And we're going to analyze today the legal basis for these claims. That is to say, we're going to unpack them and look at what are the sources of law that bear on the legal status of Israel's presence, both in a military and civilian way, in these territories. And we're going to look at what are the binding sources of international law that bear on it. Because you read in the paper, you hear on the radio, settlements which are illegal, rarely or never is there a discussion of what exactly are the international legal provisions or norms that trigger this purported illegality, and we're going to explore what the binding international law texts say on the subject. So first of all, we need to step back and Miriam said you don't need a law degree. This is international law. You might not need a college degree. It might be unhelpful. International law isn't exactly like regular law. And the question is, what is international law? Where does it come from? And it's important to say from the outset that not everything that it makes a legal claim or is on a legal subject and sounds international is a source of international law. Take, for example, resolutions of the General Assembly. They're very international. It's the UN. And they often make legal claims. They say this is legal, this is illegal. Are they sources of international law? So they are relevant to understanding what countries think international law is, but themselves they're not legislative acts. They're not the source of legal obligations. Why? Because where does the UN come from? Where does the General Assembly come from? The UN Charter. It's created by a treaty. And that treaty defines the powers of the General Assembly, and their only binding powers are over the adoption of their own budget, which they use quite well. But they do not have an international lawmaking capacity. Obviously, the countries of the world did not give it to them. Similarly, so that's a good example. So what's the force of a General Assembly resolution? I would compare it to, there's often one-house resolutions in Congress. Like the House of Representatives will pass a resolution. So it's not binding law. Why not? Well, where's the House of Representatives come from? The US Constitution. And it provides that you need a certain process at which the House of Representatives by itself is not sufficient to make law. Why do they do it? Because they're politicians and they like people to know what they think. General Assembly also likes people to know what they think. That itself is not a source of international law. International law generally comes from treaties, explicit binding commitments undertaken by countries, and a second form of international law is what's called custom, which is the repeated practice of countries over time, almost universal, can create rules which become general rules applicable to everyone. And those are somewhat harder to identify. So we're going to look at this question purely through the lens of international law. And we're not going to look at who is where first, who does God want to be there, or any other kind of normative desideratum. But this is called contemporary issues. So in the Middle East, we're going to start with 1917. That's pretty contemporary. So we can go all the way up to 1917, and everyone's in agreement. So that's pretty great, right? So we can stipulate to a lot. Up until 1917, there's no dispute as to the status of these areas. So this is the area. Does this little light go on? Okay. So this area here is the area now from southern Lebanon through what's called Israel now, West Bank, and Gaza. And it was under the control of the Ottoman Empire. It was under the sovereignty of the Ottoman Empire. Was it fair? Was it nice? Not our question. But if you asked anyone in 1917, who does this belong to? Everyone would agree. They wouldn't say the Israelis, they wouldn't say the Palestinians, they wouldn't say the Jews, they wouldn't say the Arabs. They'd say the Ottoman Turks. The Ottoman, and this are the administrative divisions. Sanjakits and vilayets are Ottoman governorship districts. And in 1917, the Ottoman Empire, like the other Central Powers in World War I, disintegrated, collapsed after having lost as a result of losing World War I. And it lost to the British and French, who came to occupy the Middle Eastern territories under the Ottoman Empire's control. In the wake of World War I, most of the countries of the world, including the victorious powers, and Turkey also joined, created a new organization by treaty called the League of Nations. So we're talking about treaty is a form of international law. The League of Nations got its power from a treaty signed by the relevant powers called the League of Nations Charter. The League of Nations Charter gave the League of Nations a variety of jobs. One of them was to oversee a system of nation building in the former colonial territories of Austro-Hungary, Germany, the German Empire in Africa, and the Ottoman Empire. So instead of the victorious powers taking these former territories as their own possessions, they would oversee them in a nation-building process on a road to independence, and this was called the Mandate system. And a mandate was the system by which the League of Nations would oversee the creation of new nation states out of the former possessions of the Ottoman Empire. And the League of Nations issued a mandate to Britain for Palestine, as the region was called. So the area in question was called Palestine, and as you see, Palestine includes all of this area that we today would call Israel, Gaza, and the West Bank, and this entire other thing. That's what was known as Palestine. And Palestine was supposed to become a nation state under the supervision of the British. The League of Nations mandate provided that this nation state should be used as a national home for the Jewish people. This is what the League of Nations said. And note, why should it be a national home for the Jewish people? Because they're from there. Because of their historical connection to it. It's the reconstituting of a national home, the League of Nations said. Now, what does it mean, a national home for the Jewish people? What exactly rights was the League of Nations giving the Jewish people over this territory here? The answer is no particular rights at all. The League of Nations mandate did not give Jews any political rights or rights of ruling or controlling Palestine. They only gave one particular special concession to the Jews, which is contained in Article 6 of the mandate. And it's the first time we're going to see the word settlement. What the League of Nations mandate allows the Jews to do is move to Palestine. The Ottomans had a very restrictive, basically prohibitive set of immigration restrictions. They did not let Jewish immigration into Palestine. They did not let Jews buy land in Palestine. And the League of Nations mandate waives those restrictions, lifts those restrictions and says Jews are allowed to emigrate into Palestine and purchase land there. Settlement. So you see, the League of Nations mandate talks about Jewish settlement in Palestine as a goal, as a permissive thing, as what the British are supposed to allow and encourage. Okay. Now, it's important to know the following thing. Most people, if they ever hear of any League of Nations mandate, most people, of course, will live their entire life without hearing of any League of Nations mandate. Most people, if they hear of if they know of any League of Nations mandate, they will have heard of this one, the British mandate, so-called the Mandate for Palestine. So it seems, well, this is just a weird, strange historical thing. League of Nations did this weird thing, created a national home for the Jewish people, a special favor. So it's important to note that the Mandate for Palestine was one of numerous mandates issued by the League of Nations in the Middle East. The entire modern Middle East arose out of the mandate system. Syria was a French mandate. Lebanon was another French mandate. Iraq was another British mandate, the Mandate for Mesopotamia. So this was not a one-off special pleading kind of thing. The entire map of the Middle East is a consequence of this simultaneous system of mandates. Interestingly, the Palestine Mandate was the least controversial at the time. There was a lot of discussion about the Syrian and Mesopotamian mandates, because that's where the oil was. If you look at the proceedings of the League of Nations Mandates Committee, the Palestine Mandate was barely mentioned. Now, there was a provision of the Palestine Mandate, Article 25. Article 25 provides the following. If it turns out to be inconvenient to administer the mandate as described by the League of Nations within this entire territory, the British can partition it and create a different regime on this side of the Jordan River, the Transjordan, and create a separate political entity there. The British immediately exercised this power in the 1920s, mid-1920s. They invited their friends from the Hijaz, the Hashemite family, to rule this area, the Transjordan, thus creating the Hashemite Kingdom of Jordan. And from here on in, we have Jordan. So if there's ever a question about, I don't think this question arises often in campuses, but if there's ever a question, does Jordan have a right to exist? It's a question that's sometimes raised about other countries in the Middle East, or at least another country. Or why does Jordan have its borders? Like, why should Jordan have that weird little arm thing? It's not like a normal-looking border. I believe it was the railroad line from that connected Haifa to Mosul. So Why have this weird border? Why have this little arm? Why does Jordan have a right to exist? Why should it be a Hashemite kingdom? The answer for all those questions is one sentence of the League of Nations Mandate, Article 25. So obviously, we accept as binding and valid into the present day the realities created by the League of Nations Mandate. See Jordan. So what's left of Palestine, so from the 1920s until 1948, this blue area, including the West Bank and Gaza, is mandatory Palestine. The British mandate expires in 1948. They end the mandate. They unilaterally end the mandate in 1948, and Israel declares independence. So the question is, as of the moment of independence, what are Israel's borders? And here, I'm going to introduce you to an important methodology and an important concept. If you're looking to answer questions about Israel and international law, let me teach you, it's not a very sophisticated trick, but it's a very powerful one. Look to see how the analogous questions are resolved and approached in situations other than Israel. Because the problem with international legal discussions of Israel is they exist in a little bubble where all of the relevant questions about what the rules are usually refer to other prior discussions of Israel. Now, what's international law? Law is a system of general rules that apply to indefinite future cases, and international law is across countries. So if you want to know what are going to be the borders of a country created in this mandate territory, look to see what happens in other situations. And there's a very powerful rule of international law, which describes what happens in pretty much every situation, called, in every situation but this one actually, uti potestetis juris. And what this rule says is when a new nation is created, what are its borders? What are the borders of a new nation? Which is created either because of the end of a colonial regime, right, when the Belgians pull out of the Congo, or the French out of Africa, or when the Soviet Union collapses, or when Yugoslavia collapses. You have all these new countries created. How do we figure out their borders? Without a clear rule, the creation of a new country would be a recipe for endless war because every possible inch of its borders would be open for de novo review. So as a result, there's a very powerful rule of stability called uti potestetis juris, which says when a new country is created, its borders are the borders of the last geopolitical administrative unit in that area. Even for example, if a country emerges from colonialism, its borders are the borders of that former colony. Even though those borders were not drawn with the consent of the people and are often arbitrary and served principally the economic or political military interests of the colonial power and divided tribes and those are the borders. Because if that's not the rule, then everything would be up for grabs every minute. And we see this rule applied all the time. It was certainly applied in every other mandate context. So to put a contemporary twist on this, the Russian warplane that was shot down by the Turks recently. It's really not so surprising that the Turks shot it down. It was shot down in a very sensitive area called Alexandretta or Hatay, depending on whether you are a Turk or an Arab. And this was part of the mandate for Syria. It was a region of Syria, which in the 1930s the Turks basically pried away from Syria with the sort of consent of the French. Might have been legal, might have been illegal, but it doesn't matter. When Syria became independent in 1943, its territory did not include Hatay, and so it was never recognized as having Hatay or Alexandretta be part of it. Syria has objected to Turkish control of Hatay ever since. But those are the borders. Let me give you another example. When Saddam Hussein, so we take the mandatory borders as binding, even if they weren't a good idea. When Saddam Hussein invaded Kuwait, he did not, as many people think. People have, I think, a limited view these days of bad guys. He didn't say, I'm invading Kuwait because I'm a bad guy and I want to invade places and get more territory. He was raising a very long-standing Iraqi objection to the borders of Iraq, which he did not invent, and which dates to Iraqi independence. How did Iraq get its southern border with Kuwait? The British drew a line during the mandatory period. Why should they be bound by the mandatory border? And they have a very powerful argument of equities, by the way, against the line that the British drew. You know, Kuwait is a country of a very small number of people. They have something like 300 miles of coastline along the Gulf. Iraq is a country of tens of millions of people. It has 30-some miles. So they had an argument of not fair. The answer, no. Fair doesn't matter. Fair, not fair. The mandatory borders are the borders. And we go by this all the time. Take the most recent example. Take Crimea, as Vladimir Putin recently did. The international community does not recognize Russian claims of sovereignty over Crimea. And the question is, why not? Is it because of ethnic self-determination that the people there prefer to be part of Ukraine? No, actually most of them prefer to be part of Russia. Not like 97% like they said, but certainly a substantial majority. Is it because they're ethnically Ukrainian? No, mostly not. Is it because it's like a colonial thing? It's just very far away from Russia and it's not right for, no, it's kind of right in the middle. Is it because it's always been part of Ukraine? No, generally has not been part of Ukraine. So what's the basis of Ukraine's claim? Very simple. In 1950s, Nikita Khrushchev, the General Secretary of the Communist Party, when both Ukraine and Russia were ruled from the Kremlin, and they were both simply Soviet socialist republics, moved the administrative border of Crimea to put it within the territory of Ukraine. Didn't ask anyone, didn't have a referendum. That's it. But the day Ukraine became independent, Crimea was within the territory of that administrative unit. That is the borders of the new country, period. We make no exceptions. So when Israel becomes independent in 1948, despite the fact that various compromise proposals had been offered by the General Assembly, you may know that in 1947 the General Assembly suggested a second partition proposal, a resplit, but that never took effect. It didn't become the borders. Why? Because A, the General Assembly does not have the power to do anything, let alone make borders. And by the way, they knew that at the time. If you read the General Assembly resolution, they don't say, these are the borders. They say, we recommend that Britain, the mandatory power, implement a compromise proposal that would look like this. And to which the answer of Britain was, thank you for the advice, and that's a crazy idea. And we're not going to do it. So so the borders remain the borders of mandatory Palestine. And that was the presumptive sovereign territory of Israel when it became independent. Now, as soon as Israel became independent, it was invaded by a coalition of Arab armies who were seeking to kind of meet in the middle, Molotov-Ribbentrop, and divide it according to some not yet agreed formula. They were unsuccessful partially. That is why we have a state of Israel. They were partially successful. That's why we have a West Bank and Gaza. So the West Bank is simply the furthest extent of the Jordanian-Iraqi thrust into the territory of newly independent mandatory Palestine. That's where the fighting stopped in an armistice. That's where they fought to a standstill. Gaza Strip was how far north the Egyptians got. They actually got further north, then they got pushed back. That's why it's the Gaza Strip. In other words, these lines do not correspond with any pre-existing administrative, demographic, or topographic lines. They're an armistice line. And what's an armistice line? An armistice line is not a demarcated border. It is not a change in sovereign borders. Rather, as the Egyptian-Israeli armistice agreement said clearly, and the Jordanian armistice agreement also said clearly, it's simply a temporary break in the fighting that does not change or prejudice actual geopolitical borders. It's the only thing they could agree on. So the so-called green line, you know why it's called a green line? So in an armistice agreement is like, it's like a break in rounds of boxing. It's like a break between rounds of boxing. The guys go to their different corners and spritz up before they come back fighting again. So you need to know where your corners are. Right? Otherwise you'll go to the same corner and shoot each other. So an Israeli colonel and a Jordanian colonel met in a hotel in Rhodes to show where their forces were on a map. The Israeli colonel had a green marker. He went, Jordanian had a black marker. Thus the green line. In other words, the very creation of this line stipulated that it does not have any legal force and does not create any different legal realities on one side or another, that it was simply the basis on which they would temporarily agree to stop shooting. So what was the status of the West Bank between 1948 and 1967? So I think there are two possible statuses. First of all, one could say it was Israeli territory, occupied belligerently by Jordan. Why Israeli territory? Yuti Patatetis Juris. For the same reason Tel Aviv is Israeli territory, it's part of the Mandate of Palestine. You could also say that perhaps to establish sovereignty over territory, you need to have at least had some initial control over it. And that because Israel didn't have initial control over this, it had not perfected sovereignty, but rather had a sovereign claim. The reason I can't tell you the difference between those two positions is there's no precedence by which we can tell. So one thing you should know is whenever someone tells you about, in the case of Israel and international law clearly says, say, really? Show me the case where we learned that out from. So there are no cases in which a newly created mandate territory, a newly independent mandate territory, is immediately occupied by multiple belligerent armies and held in a state of occupation for a period of time. That's a fairly unique question. And international law is not a dense enough system of regulation to have prepackaged answers for all that. But clearly, the occupation of Palestinian territory began in 1948 by Jordan. The United Nations didn't have much to say about it. And it ended in 1967, when Israel, in the Six-Day War, retook these territories as well as the Sinai Peninsula and Golan Heights. So when Israel retook these territories, it was taking territory that had simply been under belligerent Jordanian occupation without a recognized claim of title, and to which Israel already had a claim of title, if not actual sovereignty, perhaps, based on this UT. So let me put it this way. Let's say 19 years from now, Ukraine manages to dislodge Russia from Crimea. I mean, this is science fiction. But let's say 19 years from now, Ukraine manages to dislodge Russia from Crimea. Would we say, oh, Russia's been there for 19 years. That's it. Crimea's it. Ukraine, you're an occupier. I don't think if you were to ask people today what they'll say in 19 years, that would be what they'd say. Maybe that is what they'd say, but that is not what they would say before they have to say it, if you see what I mean. That wouldn't be the general principle. Okay. So Israel has a strong claim of title to this territory, which gets us to the question of settlements. What are settlements? Settlements are Jewish civilian presence in this territory. Settlements are defined as Jewish civilian population in the area occupied by Jordan between 1949 and 1967. That's the definition. That is to say, the notion is that the Jordanian occupation of this territory permanently changes its character in such a way as to make any future Jewish civilian presence there an international crime. Now that seems counterintuitive, and I think it is, and we'll see what's the basis for this legal argument. So now Jordan has occupied it. The argument is if Israel ever reoccupies it, they're not allowed to have Israeli civilians or Jewish civilians live in this territory. Now, what's that come from? Right, and the standard view of the international community, I'll tell you it is the majority position, is that international law forbids Israeli or Jewish, depending on how one describes the rule, civilians from living in this territory. In the territory defined as the territory formerly controlled by Jordan. People call it on the other side of the 1967 borders, But the 1967 borders, as you saw, weren't borders, according to the Armistice Agreement, and they were created not in 1967 but in 1949. Otherwise, the phrase 1967 borders is largely accurate. The entire discussion of the legality of these civilian communities is based on one sentence in one treaty, which doesn't use the word settlement, by the way. So the first thing to understand is settlement is not an international legal term of art. Well, that's not an international law word. That's a colloquial expression, actually borrowed from Hebrew. It's quite interesting that they chose a Hebrew word. For example, in French, they're not called settlements. They're called les colonies israélites. So settlements is it's an idiomatic word. The Article 40, the Fourth Geneva Convention is a convention about the treatment of civilians in wartime. Now, why does that apply today? That's a question we can talk about. And it has certain provisions about occupation, military occupation. So the first question is, and all of the discussion of the legality of settlements is based on one sentence in that treaty, Article 49, Clause 6, which we'll talk about in some fair depth, which doesn't use the word settlements. The first question is, do the Geneva Conventions apply? So there's several arguments that the Geneva Conventions would not apply. First of all, if this is territory to which Israel has a sovereign claim, well, you can't occupy yourself. That's fairly evident. Even if it's not Israeli territory, the text of the Geneva Convention says that it's a treaty between countries, not the word of God, right? It does not apply everywhere in the universe and to all things. And as a treaty between countries, not surprisingly, it applies to occupations of the territory of signatories. So does not apply, for example, to the occupation of territory of non-signatories, those that are not high contracting parties. So the question is, was this the territory of Jordan? It would seem not. Certainly if you asked anyone in 1966, they would not have said this is Jordanian territory. It's occupied by Jordan. So some people want to say, look, it applies even to the occupation of territory that's not that of the sovereign of a high contracting party, that's not the sovereign territory of a high contracting party, because these are liberal, good humanitarian rules. We want to interpret them broadly. We don't want to have gaps. It is kind of like the word of God. Or that maybe territory doesn't mean sovereign territory. It just means territory under control. So then maybe it does apply because it was under the control of Jordan. But then if it applies because it was under the control of Jordan, then it certainly doesn't apply anymore because Israel signed a peace treaty with Jordan in 1994. And peace treaties end all states of belligerence in the application of the Geneva Conventions. Geneva Conventions occupation provisions do not survive a peace treaty. So either it wasn't Jordanian, in which case it doesn't apply, or it was Jordanian, in which case it no longer applies. But let's say that it does apply. What does it actually, which it doesn't, but what does it prohibit? The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Now you see why they don't use why they use the word settlement. Israeli settlements. It raises far fewer questions than if they use the language of the provision which it allegedly violates and called them Israeli deportation or transfer centers. Because that would raise the question, how were these people transferred? Who transferred them? What was involved in this transfer? First question is this. Who does the Geneva Convention regulate? Who does it forbid from engaging in whatever activities it forbids? Not a trick question. Yes?
I believe it forbids everyone, even those that are not signatories to the convention.
Or everyone, like every person on Earth?
Every sovereign country on Earth.
Right, so it speaks the occupying power. The obligations under the Geneva Convention are the obligations of the sovereign signature, Geneva Convention. So one thing the Geneva Convention obviously does not say is the way people want to try to read it, which is the occupying power shall not deport or transfer parts of its own civilian population, and the civilian population of the occupying power shall not deport or transfer themselves and shall not be allowed to go in. It's not a prohibition on the civilians of the occupying power. It's a prohibition on certain kinds of organized, collective, demographic actions by the occupying power. It doesn't say, well, it could have just as easily said, civilians of the occupying power are not allowed to live in the occupied territory. That's how people want to read it. And that's exactly what it clearly doesn't say. Indeed, compare it to Article 49.1. So most of Article 49, and it was based and inspired by German practices in Eastern Europe in World War II, when they would kick out Polish or Ukrainian populations and move in Germans on a huge industrial scale. So, but first you have to kick out the Poles, otherwise it will be not good for the Germans to move in. So the primary prohibition in Article 49 was on the expulsion of the population. And Article 49, 1 through 5 deals with that, ethnic cleansing, deporting or transferring the people out of the occupied territory. Note the language that's used, individual or mass forcible transfers. That means in terms of kicking people out, you can't kick out all the people, and you can't kick out like individuals. Compare that to the language in Clause 6. The prohibition is on the transfer of parts of the civilian population, large-scale demographic movements. It doesn't use the word individual. There's no prohibition on individuals moving into this area. Right? So if Israelis wish to buy land, build houses, there's no prohibition on them. Not on civilians, and it's not an individual prohibition. And what's transfer mean? Transfer means taking people and moving them. There needs to be some action of moving. Now, people want to say that Israel transfers people by letting them go, by making it possible. That by providing these communities with municipal services, water, security, Israel makes it possible for them to go. Even if that's true, it seems to be to turn 49.6 on its head. 49.6 prevents certain affirmative actions, right? Do not deport or transfer. It doesn't say, and if they want to go themselves, make it impossible for them to live there, make it difficult, dig moats, put up barbed wire, and if they make it in there, make it, starve them out. That's just not what it says. There is no obligation, and the proof of this is that when they were drafting the definition of crimes in the Rome Statute, for war crimes, they simply borrowed and cut and pasted the various war crimes as defined by the Geneva Conventions. One exception, one provision they changed. Not provisions that are actually used and interpreted in like use of force and attacks on civilian populations that are actually the lifeblood of international humanitarian law, but this one provision which has never been applied in any kind of judicial context. On the insistence of Morocco, Syria, and a few other Arab countries, the words directly or indirectly were added in. They made clear to try to cover this notion of allowing people to move in. But that only underscores that that's exactly the words that the Geneva Convention doesn't have in them. Doesn't have the indirectly. And Israel hasn't signed the ICC, hasn't ratified the ICC statute, nor has America. So they might have put it, by the way, nor did the countries who proffered this proposal. Obviously Morocco, which has occupied Western Sahara and created a majority settler situation in Western Sahara, they weren't thinking this was going to apply to them either, and they haven't signed either. Nor has Syria, which sent hundreds of thousands of settlers into Lebanon. So none of the countries who profit, this was for Israel, which is why Israel didn't sign. So Israel is certainly not bound by this, and this change in language shows us exactly what 49.6 doesn't. And the problem with the standard interpretation of 49.6, I think there's room to argue that particular actions of the Israeli government, you could say, is this action a transfer, is this action not a transfer? But instead, the standard position argues backwards from a result, right? The result is it should be illegal for Israeli civilians to live in any considerable number in this territory. So now let's try to fit that into 49.6, and it can't all fit. Take, for example, what about people who are born in the area? Settler babies. Were they transferred? They were delivered. And indeed, in other contexts, when, for example, the European Union or the United Nations Human Rights Council is trying to count Turkish settlers in northern Cyprus, which is not often, they make clear, they specifically say, settlers include people who moved from the mainland to Cyprus. It does not include their descendants because they were born there. It's not a status that runs with the blood. So only in this case does it seem to run with the blood. Or have you ever heard of illegal settlements? Illegal outposts? What's an illegal settlement? Aren't they all illegal? An illegal settlement is a popular term to refer to civilian communities that are built not with the approval of the Israeli government, but against the will of the Israeli government, with against the municipal and zoning and administrative regulations of the Israeli government, and that they try to knock down. Right? And they don't have water, and they don't have electricity, and they get bulldozed occasionally. So these are the wild, radical, wildcat settlements. So if these are built against the approval of the Israeli government, shouldn't that make it by definition legal under international law? If it's illegal under Israeli law, doesn't that make it per se legal under international law? Because how can the occupying power be deporting or transferring them in when they're trying to transfer them out? But nobody says that. So these are the worst places. Now, indeed, if you want to know about settlements, one can actually learn a lot outside of the context of Israel. It turns out that this is not the only situation. For example, America occupied, do you know when the occupation of Berlin ended? 1990. It's a long occupation. And by the way, we know that in hindsight. If you ask someone in 1988 when the occupation of Berlin would say, they would say, never or the end of the world, whichever comes sooner. And it looks like the latter would come sooner. So, did anyone say Americans weren't allowed to move to West Berlin? Did anyone even think of such an idea? That it's an international legal issue if a Burger King opens up in West Berlin? Indeed, many Americans did move to West Berlin at various times for various purposes. It was kind of like a cool hippie place. Because West Berlin was not part of the Federal Republic. This is the point that I must urge on you. As a result, it was exempt from the Federal Republic's draft. So it was always like, so in the 60s, lots of Americans moved there because it was kind of cool. No one ever said, oh my God, Americans are moving to West Berlin. Indeed, the army also encouraged civilians to move to West Berlin to create a more, it was considered an extraordinary hardship post. Like the life expectancy in the event of a US-Soviet war was 5 minutes. So civilians were encouraged to move to create a kind of more home-like environment. Indeed, we find that nationals of the occupying power have moved into occupied territories in massive numbers in numerous contexts around the world, some of them ongoing. The majority of the population of northern Cyprus is Turkish settlers, the majority of the population of Western Sahara, Moroccan settlers, hundreds of thousands of settlers in East Timor, Vietnamese settlers in Cambodia. The question is, and the international community has in some cases criticized the underlying action, like the Turkish invasion of Cyprus was criticized. Security Resolution passed a resolution criticizing the invasion. The question is, have they called the civilian presence an Article 49.6 violation? And it turns out the answer is an overwhelming no. It's impossible to find situations where the UN is going to say, look, Vietnamese settlers in Cambodia, that's a war crime. They don't say it. Now, in international law, like the rest of law, let's say you have 9 cases going one way, 1 case going the other. You could say it's the one case that's right and all the other 9 cases should be revised in light of it. And that might be true as a policy matter. But as a legal matter, we generally say the 9 cases represent the best fit line that is the legal norm, and the 1 case is the outlier. Okay, I want to leave time for questions, so I should stop right now. Yes, please.
Previous slide,
Yeah, I shouldn't even have put it on because I think it's less than a question mark. Probably I should also do the same with the Baltics. Because I'm a formalist, and the question is this. So first of all, assume Tibet was an independent country, which you may or may not think. The prohibition on transfer into an occupied territory is solely a function of the Geneva Convention. There was clearly no such customary or Hague Convention-based rule beforehand. The Chinese takeover of Tibet occurred prior to China's signing of the Geneva Convention, which was in 1950-something, I believe. And the question is, does the Geneva Convention's provisions on occupation apply to pre-existing occupations? I don't think anyone's answered this question, but my instinct would be surely not. And I think that's the case for the Baltics too. I only put it on because lots of people ask me, what about the Baltics, what about Tibet? So I think those are differentiable on this formalist ground that it was subsequent to their signing of prior to their signing of the Geneva Convention.
Can you explain West Jerusalem, Israel's Crimea?
Where did I say that?
That was on a previous slide.
Did I say Israel's Crimea? I forgot what I meant by Israel's Crimea. No, but think about this. So West Jerusalem is not considered by the United States to be part of Israel, to be a sovereign part of Israel. But yet Israel's there. And if the rule about settlements is any movement of people, civilian people, of a country to territory that it does not have sovereignty over, is settlement, why is the Jewish civilian presence in West Jerusalem not considered settlement? It's very hard to distinguish. As for the Koreas, the point of the Koreas is one of them must be occupying the other, because the territorial claims of both Koreas are 100% congruent. Right? North Korea is not saying the North belongs to us and the South to you, and South Korea is not. But so both of them are saying there's only one Korea and it belongs to us, which means one of them at least must be occupying half the territory of the other, and obviously many civilians live there. So why does it not say, oh, you're not allowed to live there because it's occupied territory? Someone's definitely occupying someone there. And to be more precise, actually, at the end of the Korean War, both the North and the South held some positions north and south of the 38th parallel. And indeed, there is a North Korean town that's south of the 38th parallel, and that has a population that's built up after the war. No one has ever suggested that this population movement to an area that the Democratic Republic of Korea took control over during the war represents illegal settlement in occupied territory in violation of the Fourth Geneva Convention. Yes?
So why is Israel treated so differently than these other countries?
I don't know. I'm not a psychologist. I'm not a social psychologist. It's probably easier. I mean, if you are a student of international humanitarian law, and you go, a scholar of international, and you go to Hebrew University, and you deliver a lecture about the illegality of Israel's presence in the West Bank, you will be saying, oh, good job, thank you for coming, very nice, we like to have an exchange of views. If you deliver a lecture in King Mohammed X University in Rabat about the legitimacy of Moroccan presence in Western Sahara, you're definitely not coming back, but you might not even be leaving. So it's maybe easier, but that's not a complete explanation. So I can't deduce motives. I'm just a scholar of what happens. Yeah.
Even if Israel's occupation of the West Bank and the Gaza Strip was illegal, and I'm not saying it is, I'm actually very convinced by your presentation, what does it matter? The ICC has no enforcement power under international law. The only ones that have enforcement power under international law to do anything is the Security Council, of which the 5 permanent members have a veto. And the United States is never going to agree to something that sanctions Israel or its own interests, just like Russia would never do something to sanction its illegal occupation of Crimea. So ultimately, why is this just not a battle of semantics?
So first of all, the heavy betting is that the United States will actually not veto a very problematic French Security Council resolution. And will actually, the long-standing U.S. policy is as if you described it, and that policy does seem to be perhaps coming to an end, first of all. Secondly, I'm not saying it's so important. Right? I mean, this is just, I'm not one of these people who does international law and then has to sell the importance of international law. But I don't think it's so not important. And I think the best evidence for why does it matter is when people talk about this situation, they always try to do it in international legal terms. So I don't know why that is, but it seems to have some particular kind of purchase. Because I think it's easier to say, look, there's these general rules of international law that everyone lives by, of which one particular implication just happens to be Jews can't live in the old city of Jerusalem. We've got nothing against Jews in the old city of Jerusalem. That's just incidental application of generally applicable rules. So, okay, rules are rules. That may sound a little more palatable than we just don't like Jews living in the old city of Jerusalem, which sounds more problematic. So there's a reason people try to couch things in legal terms. Yes?
Why does Israel itself, in its policy and in its doctrine, accede to some of these distinctions? If in fact it's got a slim basis in international law, so like the 2005 deoccupation, right? I mean,
So
if it was
having
occupied, why?
having the sovereignty or title to territory doesn't mean you can't give it away. So Israel's position is we have a right to it. We are eager to waive or trade this right in an appropriate deal. Having rights doesn't mean you can't waive them. Okay, thank you guys so much.